The biggest thing is to keep your invention secret until you've got that filing date, until you've got that flag in the ground to say, I've got a patent application on file. The most amusing one that I remember is there was I think it was a PhD student who had done their PhD on something, and it was stored in the university library. Library records show that nobody had ever taken this book out, but because it was in a library, that counted as a public disclosure, even though nobody had seen it, right? And so down the line, somebody, I don't know if it was her or a third party, couldn't get patent protection for the contents of that PhD. So that's the sort of thing, and there's lots of case law around that. But broadly, there's one takeaway from this podcast is for inventors and founders to keep things secret until the patent application is filed, because I've seen so many things go wrong. I think we're going to come to that later.
Welcome back to the latest episode in the Sign podcast. I'm very pleased to be joined today by Adam Kelvey from Reddie Grose, and we're going to talk through all things IP protection, patent, trademarks, and the like. To avoid doing the thing that I'm told I do all the time, which is where I do the complete introduction to you and then ask you to introduce yourself at the end. We'll try and do it the other way around. So I'll finish there. And do you want to give us a bit of background on you and Reddie Grose?
Fine, sure, yes. Thank you, Paul, for having me on the podcast. Yes, my name's Adam Kelvey. I'm a patent attorney at Reddie Grose, which is they call themselves a boutique IP firm. So we handle patents, trademarks, designs, I think even plant varieties, although I don't see many of those. I've been there for about 10 years. But before that, I was at university. My background's in material science and engineering. So I handle sort of, they call it engineering materials and consumer products. Nothing too electrical, nothing too sort of bio and pharma, sort of stuff you can physically hold.
Amazing. Well, thank you for joining us. I think we've got a fair few different things that will be interesting to the audience to run through today. Probably a good kickoff point is I think that lots of founders out there are probably kind of aware that they need to obtain some kind of patent protection for their products. You know, obviously they're always very busy. They have limited funds as well, maybe at the start of the journey as well. So I guess the initial question is, why should they prioritize patent protection?
Thanks for that, Paul. I think I'm going to be a bit contrary at the start of the pod and say founders don't need patent protection. Lots of businesses function perfectly well without patents, and I think if you think of patents in that way, like just a tick box you need to just get done, like tax or compliance, you're not going to get the best value out of your IP protection. I think it's best to think of patents as a business tool, something which you use to help you achieve your business objectives. And there's lots of really good reasons to have patents. Let's be really clear. You know, they're not duds. Let's just run through some of them, shall we? They are. The headline sort of feature of them is to deter competitors, right? You've got a patent, it can stop your competitors from entering the marketplace. Sometimes just a patent on its own is enough to do that, to scare them off. But you've got to also think, okay, I've got the patent. What am I going to do if someone still enters the marketplace? You know, am I going to sue them? Can I afford to sue them? You know, do I have to get litigation insurance? But away from sort of the main reason to get patents, they're also really good for attracting investment. We've all seen Dragon's Den, where you hold your patent up and Devon Meaden, says,
I sit to the back of the room.
Has a good look at it. Yeah, exactly. Yeah. But that's real, right? That's the real world of investment. They're also quite a good marketing tool. You can slap patent pending on your product or put it on your website. That still, I think, goes some way to building consumer confidence in you. You can use them as a revenue stream. So even if you're not going to make the product you've got a patent for, you could license it to a third party, right? Or if you're going to make it in the UK, you could license it to a US company to make it in the US. You know, you could sort of do things like that. And I suppose the final one is certainly in the UK, there's a tax relief element to having patents as well. There's this thing called patent box, where if you can show that a certain portion of your company's income comes from IP, you can get corporation tax relief on that. So there's lots of good reason to get patents, but just thinking I've got an invention, so I need a patent. And there's a danger there you're not going to get full value. So on the flip side, what I also see is people thinking patents give them some sort of validation. And often this is people who perhaps have sort of retired, they've been working away in their shed, maybe they've remortgaged the house, and they've got something, and they think, if I get a patent, that will really show that what I've been doing is worthwhile, and I've not bet the house on a pup. I would caution against doing too much of that, the sort of vanity patent filing. Again, that's not using patents as a business tool in my mind. So, yeah.
Yeah, I think that's really interesting that a patent on its own is a thing that people can think is success, whereas quite clearly
it's a means to an end. It's not an end in itself.
Yeah, exactly. So there's lots more from a strategic point of view involved in it. It's, as you say, it's a business tool. I guess you've talked about kind of inventing in their bedroom and everything else there as well, and there's obviously a wide spectrum. So when should a business owner be considering protection for their ideas and inventions?
That's a key decision that founders have to make. Ideally, they make it in collaboration with their patent attorneys, but it's not a straightforward answer. There's a few factors to consider. And let's think about the situation where you apply for a patent too early, for example. What happens then? Well, I've been in meetings with potential clients, and they've got this great idea, and I say, okay, this is really good. So when are you going to market? Where are you going to make it? And they say, oh, well, I don't know that yet. I said, well, okay. So you've got this idea, but you really don't know how you're going to make money out of this invention, which is fine, right? Not all inventions have to make money. Some things can just be really good. The issue is that all patent portfolios do cost money. So unless you've got some business plan to generate revenue from an idea, you're putting the cart before the horse, I think, if you're saying, right, I need patents first, and then I want to work out how I'm going to make money out of it. And also, founders often think of patents as just sort of this one-off cost in the ladder of launching my business. Got the funding, get the patent, and then move on. Unfortunately, that's not how patents work. It's actually quite a process, and it can end up costing, quite a bit of money.
Yeah, I think there's lots of things that I think people can think of as being that kind of one-off cost to complete it and move on. But maybe you can expand on that a little bit more and give us an overview of what the kind of key costs in filing a patent are, when they need to be paid, that type of thing.
No, that's a really good question, and founders need to understand this before they pull the trigger. They need to go into this process with their eyes open. I often think of a patent application like a train hurtling down the tracks, and once you start it, it's quite hard to stop it, and you can if you stop it, you can be in a worse position than when you started. So you really need to be able to keep it moving. So back to the beginning. Initially, the first cost is the drafting and filing of a patent application. And if it's a British inventor or applicant, we probably file a British patent application first. In the UK, we're quite lucky actually. Official fees are quite cheap and you get a fairly reasonable search. So there's no reason really why you wouldn't. And that's important. Once you file first, you get your filing date. And that's important because when you file your application, you get a filing date, which is key because whether or not your patent application is new or your invention within the application is new is determined based on that date. Once you've filed your patent application, you can then go and launch your product afterwards. But if you launch it before, then your product isn't new. So anyway, so you've got your application date at time 0. More substantial costs arise in 12 months' time because we have a system, and it's almost every country in the world signed up to it, part of the Paris Convention. And at 12 months from the initial filing date, you can do what's called claim priority to that initial filing date. You can't do it later than 12 months. And what that means is at 12 months, you need to decide which other countries you want to file a patent application in. Because it's all very well having your patent in the UK, but if someone launches and sells a product in Japan, then you can't do anything about it, right?
Yeah.
And so this is where the costs do start to add up. If you want protection in, say, the US, China, Japan, the UK, and Germany, you're paying filing fees in all of those jurisdictions. You're paying exam fees in all of those jurisdictions. It does get fairly expensive. And actually, selecting which jurisdictions you want patent protection in is another key decision. It clearly depends on your markets, manufacturing base, where your key competitors operate. But broadly, for most industries, if you've got the main economies covered, say the US, Japan, China, Korea, and a few European ones, it's often then uneconomical for competitors to tool up because you've basically covered 70% of the global market. So why would they bother? But this will clearly depend on your industry. I have clients who perhaps aren't so familiar with the system, and they say, right, I've got this UK application. It's now 12 months. I want to file everywhere. And I say, well, do you really? Is that the best use of your resources? That I give them the cost estimate, and it's sort of, easily over 100 grand. And well, obviously we're not doing that. It can depend on the industry. I had a friend of mine, also at Reddie Grose, who sent around an email a few years ago asking if we knew of any attorneys in, I think it was Antigua, St. Kitts in Nevis and Tuvalu, because they happened to have a client who had some sort of dredging equipment which only worked with a specific type of sand from tropical islands, right? Yeah, so I think where you file can be very specific to your industry.
Yeah.
You might not bother filing in Saudi Arabia if you've got a quilted jacket invention, for example, or whatever. The exception to this is pharma. Just as an aside, the amount of money involved in drug discovery and pharmaceutical research means that they almost always file basically everywhere,
right?
Because even though there's lots of money in the sort of the cost of getting a drug to market, it's a rounding error. So and they just squeeze every dollar out of that R&D that they can.
Yeah.
Anyway, that was a bit of an aside. Sorry. So you've entered your patent in all these other jurisdictions at 12 months. As I say, each of them needs to be examined by the individual patent offices. Those costs add up, and then almost always, even if your patent gets granted, you have to pay maintenance fees or renewal fees. You may have heard of these, just to keep them alive in all these jurisdictions. And that's basically so that countries don't end up with lots of sort of zombie patents floating around that no one really cares about anymore. So yes, the costs add up and founders need to go in with their eyes open.
Amazing. Okay, so there's the commercial piece around understanding the right jurisdictions and everything else and getting the timings right. So obviously some corporates will go everywhere, but as you quite rightly said, choosing the right places is dependent on the business. And if you're not a big pharma company, is there anything that founders can do to protect themselves, maybe for less, before they're willing to pull the trigger on everything?
Yeah, that's right. I mean, these numbers do sound alarming, and it can put people off, but there are things you can do to keep these costs under control. The biggest thing is to keep your invention secret until you've got that filing date, until you've got that flag in the ground to say, I've got a patent application on file. As long as your invention's secret, you can delay filing the application. That means you can delay the costs associated with filing that application. Obviously, the further you get down the road to market, the harder it is to keep things secret and contained. So there needs to be a balance there. But it might involve using non-disclosure agreements when you're talking to suppliers or investors. If there's one takeaway from this podcast, it is for inventors and founders to keep things secret until the patent application is filed. Because I've seen so many things go wrong. I think we're going to come to that later. But from a patent filing strategy perspective, there are other things we can do to push costs down the road. So I mentioned when you get to 12 months, you need to choose all the different countries you want to file your patent application in. That's true, but there is quite a neat system called the Patent Corporation Treaty. So rather than filing in every country all over the world at 12 months, you can file one, it's called an international patent. And what that means is it gets examined centrally, and then at 18 months time after filing, then you need to decide where you're going to enter. You still need to pay the filing fees for all the countries you want to enter, and you still have to make the decision, but it kicks the can down the road by another 18 months. And for sort of startups and scale-ups, that can make a big difference. That could be different rounds of funding could have arrived by then. So I often find startups get into a bit of a flap maybe at 12 months from filing, but by 30 months, they're in a better position to bear those costs. And also it pushes to the point at which they have to decide down the road as well, right? At 12 months, they might not have decided what jurisdiction is important, but by 30 months, they've got a better idea of how they're going to make money out of this thing and where the big markets are going to be.
Yeah, that makes complete sense. To take you back a little bit there, obviously one of the key things that we talk about is validating ideas and verifying them and everything else. But in there you said one of the most important things is to keep things secret. So perhaps you could tell us a little bit more, as daft a question as it may sound, what secret means to people and what it should mean to people in this context.
Well, I mean, this is quite a sort of a legalistic answer. In the context of patent law, secret, what we mean is that the invention hasn't been disclosed to the public before your filing date. And disclosed to the public means made available to the public in any form by anyone. It could be by you, it could be by a third party. I mean, there's some interesting case law that sort of comes from this. The most amusing one that I remember is there was I think it was a PhD student who had done their PhD on something, and it was stored in the university library. The library records show that nobody had ever taken this book out, but because it was in a library, that counted as a public disclosure, even though nobody had seen it, right? And so down the line, somebody, I don't know if it was her or a third party, couldn't get patent protection for the contents of that PhD. So that's the sort of thing, and there's lots of case law around that. But broadly, keep it within the company, and if you're talking externally, use non-disclosure agreements if that's appropriate to do so.
So you talked a little bit about timings and delaying decision making and things. I guess with everything in life, it's always a balance, right? So what can happen if somebody waits too long to make a patent application?
Yes, there are several risks with leaving it too late. The first is, I think we've covered several times already, is that they can shoot themselves in the foot, right? You could have launched your product and then think, right, now I want to file a patent application for it. Well, you can't do that. If a product's launched, it's obviously in the public domain. I mean, unless there's something about it which the public couldn't derive from looking at it, but that's quite rare.
Makes the job a lot harder.
Yeah. But broadly, if it's out there, then you can't get a patent for it. And I think that I've had several people who sadly were in this position when they came to us. One classic one was an inventor from Cornwall who had a new kind of clock face. And I said, Adam, can you help me get a patent for this? And I said, yes, we can help with that. Send over the details of this clock and we'll put something together. And I said, oh no, it's fine. It's all on the internet. Have a look on it. It's all on our website. I said, oh, it's all on the website, is it? Brilliant. The website that everyone can look at. I said, yeah. I said, well, unfortunately, if it's on your website, it's all in the public domain. You're not going to be able to get a patent for it. So yes, don't shoot yourself in the foot. Get your patent application on file before you launch it or even publish your invention. That's the sort of the first order risk. Obviously, the risk is if you can't get a patent for it, then once you've launched it, a competitor could copy you, right? But sort of going one step further, if we were in an industry where, probably like pharma, where lots of different parties are all just at the cutting edge of the next big thing, let's imagine you don't file your patent application first, your competitor does, and your competitor is working on the same sort of thing, so their patent application would cover what you're doing. They file the application, so not only then are you unable to stop them launching, they might better stop you launching as well, right? And there are rules in UK law that if you can show you've made serious preparations to launch a product, you might be able to carry on working it. But basically you don't want to be in that position,
Yeah.
right? You don't want to be trying to do business with one hand tied behind your back. So that was a long answer. The short answer really is just talk to your patent attorney. They can give you a understanding of the costs involved in your case, the timeline that might work in your specific case, and the filing strategy that will work in your case. And even if the answer is, right, okay, well, we're not ready to file yet, go away, come back in a few years. I've had clients who've done that. I've had an initial talk to them. We've agreed that perhaps patents aren't the right thing for now. They need to do a few more things first, but then they come back in a couple of years' time and they're ready for it. But I think it's good to make that decision sort of consciously rather than sort of falling into it and then risking you're doing it too late.
Yeah, 100%. Go forward with your eyes open, helps you understand and make a decision rather than have it made at you, right?
Yeah.
Yeah, we've talked a lot about that kind of startup phase and everything in there, and I think it sounds really good from a startup scale-up point of view. What about for the larger organisations, for corporates and the like out there? What considerations should they have in terms of patent protection?
Yeah, I mean, the fundamentals are the same. So we're all playing the same game, the founders, the startups, but also the large multinationals, all playing the same rules. But in my experience, that larger organisations, whereas sort of founders might be using IP to get investment or for marketing, at the other end of the scale, big multinationals are really using it as a business tool and taking that to the next level. They're using it to make life harder for their competitors and to gain a competitive edge in the marketplace rather than, say, to secure seed investment. So a good example of this is patents can take sort of between 3 and 5 years from filing to grant, and this surprises people, sometimes much longer than that. I think certain US legal dramas give the impression that that patents are basically granted by return, and that's not the case. And when I tell some of my clients this, they're alarmed. They're like, well, this is no good. I want this granted, tomorrow, please. You can't do that. There are things you can do to speed up patent prosecution and get things granted faster. But larger, perhaps more client-savvy organisations aren't as concerned about this. In fact, they might want to deliberately slow down patent applications because while a patent application is pending, the scope of protection can be amended and shifted and changed, which for a third-party competitor watching this patent application progress through prosecution, they can't predict what it's going to end up like, right? So they can't really design around it. They can't go to market with a product which they think doesn't infringe because maybe at the last minute it will change and it will infringe. So basically you maintain uncertainty for as long as you can by keeping things pending. We do this all the time. We keep things pending really just to throw uncertainty at competitors. And then even once the patent eventually gets allowed, because you can't mess around forever with patent officers, they will either grant or reject it eventually. You can file what are called divisional applications from the original application just to keep things pending even longer. And you end up with sort of 10th generation divisionals that were filed in sort of, I don't know, 10 years ago, just to keep things pending, just to keep uncertainty for competitors. And that's sort of the mindset that I think larger organizations get into. The other thing you can do is that patent protection doesn't have to just be for your own product, right? If you have a competitor and you're pretty sure they're going to launch a product in the near future, but there's aspects of it which haven't been disclosed yet, but which you nevertheless are 90% sure will be in there, you could file a patent application to that, right? Or you could file 10 patent applications speculatively, and maybe 2 of them actually do land on what your competitor's doing and they annoy them. And so you can sort of cause headaches to for your competitors by doing things like this. And this sounds like patent attorneys just being silly and just wasting clients' money, but this is real. And I think to the layperson who thinks, I've got an invention, I want a patent for it, job done. But again, patents are a business tool to help you achieve your business needs. And even if you're not going to enforce these patents against your competitor, they could be a negotiation tool, right? You could bring a stack of patents and they bring their stack of patents and you sort of mutually agree okay, we won't sue each other in this case. Again, it's the mindset that patents are a business tool to help you achieve your business objectives.
So you can use them to create that kind of leverage for different strategic goals, right?
Exactly.
Yeah, amazing. So I guess for larger organisations, because there's a lot of complexity in there, is there anything specific in terms of challenges that they should be looking out for?
The biggest challenge, I think, for larger organisations is just keeping track of their IP. So at the start, when you're dealing with founders, they are normally also the inventor, or at least one of the inventors. And you're normally dealing with one, maybe two patents initially. So keeping track of it is very straightforward. But larger organisations, they might have big in-house R&D departments doing all sorts of research, and keeping track of that can be tricky. So sometimes there's sort of forms that inventors need to fill in that then get passed to the patent attorneys to turn into patent applications. But inventors, in my experience, they're very bright people. They don't want to be filling in boring legal paperwork, right? They want to be working on the next thing. And so some organizations include incentives, sort of financial incentives for every patent application that gets filed in an inventor's name. Sort of the amusing consequence of that is that you end up filing patent applications with sort of 15 inventors listed on it. And you think, did you all actually contribute to this, really? Or are you just all there for the bung? So that's quite amusing. But even then, though, I think training is needed for people who work in R&D. They need greater awareness of the value of their intellectual property. I mean, I've been on tours of clients' R&D departments, and they're very proudly showing off their new product or the prototype product that's going to launch in a few months' time. And quite rightly, there's maybe 5 patent applications covering different aspects of it. But I sort of look over there, what's that sort of rig you've got over there? I was like, oh, that's just a jig we use to make manufacturing of the product easier. It just saves us a bit of time. I was like, oh, right, is it? It's quite clever, is it then? Oh, it's very clever. Have you got, are we filing on that? Are we protecting that? You know, so, and the method, for example, you know, is the method you're using to manufacture this, so was that new? Oh yeah, we had to invent this new process. Oh right, are we bothering to file on that? So I think it's just an awareness that not just the final product can be protected. If you're using specialized equipment to make it, if you're using a specialized method, if you've developed new materials, sort of every aspect should be thought about. And so I think, yeah, regular training for people who work in R&D in these departments, it would help catch things and stop IP, valuable IP, from slipping through the net.
Yeah, amazing. Yeah, because I imagine that most of the time they're just looking at the headline piece, the thing at the end of it, right?
Yeah.
So I guess the next piece is a lot of people that are watching this. Some of them will be involved in physical products, so you know they might be looking at IoT devices or medical devices or whatever it is. But lots of listeners will be involved in the production of digital products, buying selling digital products, and the narrative that they will have heard over and over again is that patents aren't for them. It's not for digital products. Is that right?
I think getting patents for software and apps, it does get a bit of a bad name. I think it's given a bad name. At Reddie Grose, we've got an entire team dedicated to software and electronics patents, and they don't just sit there all day twiddling their thumbs. So there's clearly something they can do. But no, it's in Europe and the UK, it can be difficult to get patents granted for pure software, because I think that the reasoning is that software is just code, right? It's just computer code, and code is protected by copyright protection, because it's just stuff written down, right? And just like a book or whatever. In fact, there's specific rules in the UK and Europe which excludes patent protection for, let's get this right, schemes, rules of methods for performing mental acts, playing games or doing business, and programs for computers, which sounds pretty bad. It sounds bad, right? But actually, it's not quite as simple as that. If you can demonstrate that your software or your computer implemented invention has a technical effect, you may be able to get a patent for it. And this technical effect can be real in the real world, or actually it can just be in a computer. right? So let's do a little sort of example. If I've got an application which runs a language course for me, for example, it really doesn't do anything beyond what I could do in a classroom or what I could do from a book. You may struggle to get patent protection for that sort of app, right? I'm not saying that they exist, but you may struggle. But let's imagine now you've got another app which controls your home's central heating, and it does that by monitoring the weather and energy costs and your location, and it optimizes for your sort of home temperature when you're there based on some clever algorithm. And if that doesn't exist, we should definitely patent it. I mean, that sounds brilliant. That would be an example of something of an app or some software which solves a real world technical problem.
Yeah.
And in that case, you might be onto a winner. But I was talking to a colleague of mine before this pod, and actually it gets even more interesting, because the technical effect doesn't even need to be in the real world. He had a client who had developed some software, which was the software was intended to run through some code and spot errors, but it spotted errors in a unique and clever way, which obviously I wouldn't explain in detail, but I don't think we've got time. But the long and short of it is that it saved computing power and therefore energy, even though there was no effect in the actual real world. And that patent was granted for that in the UK and Europe. So I think it can depend on often whether your patent attorney can demonstrate this technical effect. So this is a particularly opaque area of patent law. So I would strongly suggest talking to your patent attorney before coming to any conclusions about whether you can or can't get patent protection.
Yeah. So I guess the main thing there is that it isn't a straight no, that it is worth the conversation. It is worth looking at least in the initial, to understand whether there is.
Always worth a conversation with a patent attorney. That's what I always say.
I think we've covered off quite a lot, haven't we? So we've talked about, we've talked about the reasons for it. I think if there's one kind of major takeaway, is that it's a business tool, right? We've talked about jurisdictions. Yes. We've talked about getting the timings right. We've talked about keeping things a secret and what a secret is as well.
Yes. Yeah.
We've talked about what IP can look like inside larger organizations and how to spot it and everything else in there as well. And then obviously we've talked about the digital side of things as well. Is there anything else I've missed off that list?
No, I think we've covered most of it. I think the main takeaways, sort of practically, one is keep your invention secret until something's on file. But two, I think we discussed the risk of pulling the trigger too early, and that can cause sort of financial headaches. But there is also almost no risk in talking to a patent attorney too early, right? Yeah. If you're in any doubt on any of these issues, do get in touch with a patent attorney, and they'll be able to talk you through and come up with a filing strategy which suits your business.
Yeah, amazing. Well, I mean, the good news is I happen to know a very good one, so
these doors always open.
That's fantastic. Thank you very much. Really appreciate you coming on. Really appreciate you running through everything with us. It's been really interesting covering it, and really, I think, shining a light on the fact that there's so much more to it than just a tick box exercise, and how it can really help people propel their businesses forward from a strategic point of view. So thank you very much for your time.
Thank you very much for having me on. Cheers.